Hello, I'm Dominic Walker, JMW's Inside Man. My guest is Zainab Hussein. Zainab is a solicitor within JMW's Employment Law Department. So, Zainab, I believe the Chancellor is going to bring back the statutory sick pay rebate. I just wonder if you can give us an update, a little bit of a sort of a latest on that.
Yes, Dominic, so he is reintroducing the rebate scheme, and effectively that is for employers with less than 250 employees. So they can recover up to 2 weeks statutory sick pay for each employee that's suffering and off work from COVID or who is self-isolating because there's a potential COVID infection. The scheme does apply to any days of incapacity after the 21st of December, which allows employers to then obviously reclaim the back pay from that period. And I think it just gives businesses some comfort at this time because there are still very high absences because of COVID, especially when employers are operating in the hospitality sector. We've seen that our clients in that sector are having really bad issues with employees that are off, meaning that the business has to then close because they don't have enough staff to actually carry out their operations day to day, or they have a large amount of employees that are just off and they need obviously sick pay to cover, the cost of them being off and not being paid under their contracts. So I think it's good because it gives businesses that cash reserve to fall back on.
So you mentioned that it will provide comfort for employers. Mm-hmm. I mean, in real terms, what does it mean for employers?
So it means that they can claim back the SSP payments for those weeks. So in the ordinary circumstances, the employer would obviously pay the SSP. The employer would usually set out their position in the contract. So you're entitled to SSP or you're entitled to X amount of sick pay contractually, then the position might revert to SSP. So the employer can claim back for those employees that they're actually able to claim for. The SSP rules are very complicated and I don't want to give any headache by rehashing them here, but the basic position is that if an employee qualifies for SSP on the day of their entitlement, which is considered day 4, they can be paid sick pay or SSP from that day. The first 3 days are considered waiting days, and as soon as the employee hits day 4 and they hit that threshold, the employer can claim the SSP. Now, with the COVID specific rules, what it means is that as soon as the employee hits day 4, they can claim from the first day that the employee is off, so day 1. So it's fair to the employee as well, really, who may have to self-isolate or maybe off with COVID. In terms of what employers need to look out for, it's quite important to make sure that you understand the intricacies of the sick pay rules. An employer often has contractual sick pay in the contract. So an employer will say you're entitled to 1 week's full contractual pay. The position will then revert to SSP. Now, you can't claim the contractual pay back because that's a contractual payment that you as an employer owe to the individual. I think it's going to be interesting to see if any businesses try and, commit some kind of fraud by kind of push through the contractual sick pay element, and obviously that won't wash. So employers need to be really careful and make sure they are actually claiming for the SSP entitlement as opposed to anything that they're offering in the contract. And I would advise that they look at the contract and look at their policies and see what they're currently offering and then make the claims on that basis. A good thing to do is to also keep a paper trail. Obviously, when HMRC do a look back on the claims, they will say, well, when was the employee considered sick? Did they have a lateral flow test or COVID test on that day to show that they were sick? And how long were they sick for? So that we can consider whether or not the SSP has been paid out at the correct amount. The limit is 2 weeks. And obviously that does place some difficulty if somebody's off for longer than that period of time. But I think that matches the standard usual period of time where a person has COVID and then has symptoms and then is on the way to recovery. After 7 days, usually employers in normal circumstances require an employee to produce medical evidence, so like a doctor's note. Up until that point, they self-certify. I think there's going to be practical challenges after the 7th day because the NHS is currently under a lot of strain. So to get that sick note might be difficult. So I think an employer needs to think about how can we adjust this policy or make it flexible in the meantime so that we can then, allow the employee to be off pay, obviously pay them the SSP and then claim that back and make sure that we have a good enough paper trail to show that we're claiming that back for SSP and not anything else. I think businesses need to be careful, make a paper trail and understand the rules and then they'll be able to claim from the scheme and have the comfort that they're not going to, if there is an investigation, they've done everything they can to cover their base.
And you mentioned about the rules can be a little bit complicated. You mentioned paper trails, and you even allude to the fact that some employers need to be very careful they don't fall foul of these rules. It's always good to have somebody who you can sort of speak to who knows about these sorts of things. So, can you help employers in those circumstances?
Yes, definitely. So we can help assist, and especially when there's complicated cases, we can help with that and help with the SSP rules.
Excellent. Zainab, thank you very much for your insight. And if you'd like to contact Zainab or the employment team, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.